Hey guys, this is Dr. K. So today we're going to be talking about legal issues in nursing for your professional role course. So I know that you guys have probably heard a lot about malpractice. I'm not going to beat a dead horse. Malpractice, professional malpractice, is a type of negligence that results when a professional person fails to perform his or her professional duties in a reasonable manner. So, more and more nurses are being named as defendants in professional malpractice lawsuits. And if you think about this, nurses have a lot of liability. So that's why we tell you guys to document, document, document. If you didn't chart it, you didn't do it. If you guys ever get called to court over a case, you will have taken care of probably hundreds, if not thousands, of patients. If that ever happens, I hope it doesn't, but if you ever do get called, you're probably not going to remember every little detail about every little patient. So that's why anything of major importance, we document, 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 because your charting is ultimately what is going to save you in a court. So, sources of law. So, law, by definition, is any system of regulations to govern the conduct of the people of a community, society, or nation in response to the need for regulatory consistency and justice based upon collective human experience. So, there are four basic sources of law, and all of which govern the practice of nursing. So, the four sources are federal and state constitutional laws, laws passed by federal and state legislatures, common law, and administrative law. So the primary source of all law in the United States is our federal constitution. Each state also has a constitution, and it's also an important source of rights. And if there's any conflict between the provisions of a state constitution and the federal constitution, federal law takes precedence. So that is known as federal supremacy. Congress and state legislatures serve as that second source of law. And then each state's Nurse Practice Acts, kind of like we talked about last week, is a state statute that specifically defines the legal limits of practice for nurses within that state. So common law or case law develops as a result of judicial decisions that are made in settlings of cases or disputes. So primary source of law, Constitution, that's the big thing. It sets the powers and limitations of the federal government. And then the first 10 amendments, also known as the Bill of Rights, kind of a throwback to probably your middle school history days. So the Bill of Rights addresses concepts such as your freedom of speech, press, religion, right to assembly, right to not be deprived of life, liberty, or property without due process. So next we're going to talk about civil law versus criminal law. So civil law dictates behavior between private parties, and criminal law serves to protect the public from harm by punishing persons who break societal rules. So a person may be acquitted of criminal wrongdoing, but they may be held civilly liable. And then civil laws, or their disputes, take the form of a lawsuit. So civil laws are going to be those lawsuits that we see come to fruition out of certain situations. So parties legally claim something against another. It's the cause of action. Examples can be tort law and contract law. So those tort laws are laws that establish rules for socially responsible conduct. And then the contract laws are, it governs agreements and enforces those agreements between the parties. Criminal law is just the state brings criminal action against the accused and they must prove the case beyond a reasonable doubt. Those are probably the ones, or the one that you're most familiar with. So, resolution of disputes. So, courts allow for the resolution of disputes by providing a forum in which the facts can be heard and the law applied. So, when making a decision about an issue, the judge has several things that they have to consider. These things typically include interpreting the relevant statutes, considering the legislative intent, and then comparing the facts to similar prior cases. So decisions are then rendered, and they may serve as a precedent and establish principles or rules that courts may adopt when deciding subsequent cases with similar situations. So our judicial system, it's a federal question jurisdiction. So the court system is for deciding disputes involving the federal law. If someone is dissatisfied essentially with the outcome of a case at the trial level, then they typically make an appeal for the decision, and it's part of their rights, and they go to the next level of court. So the court, the court requires that the appellant then show that the decision of the agency was arbitrary and capricious for reversal of an administrative ruling. Then it goes on to a three-tiered structure. So we have the lowest level, which is trial court, and that is responsible for discovering the facts and applying the law to a wide variety of subject matters. The second law is the appellate court, and they review only issues of law related to dispute, and they do not revisit the facts of a matter. And then our third level, obviously, it's the state's highest court. Names typically vary, or it's the Supreme Court. So the Supreme Court, if the person is disappointed at the appellate level, then they can appeal to this level of the court. The court can refuse to hear that appeal, and if so, the decision of the appellate court stands. So now that we've kind of done a brief recap of your middle school history years, now we're going to kind of get into more of like the legal side of nursing. So the legal issues in nursing practice and the regulation of nursing practice. So obviously the regulation of nursing practice is there for safe and appropriate care for patients. So without it, we really wouldn't have a basis of what would be deemed appropriate, what would be deemed, a standard level of care, things like that. So nursing practice requires more than knowledge of patient conditions and treatment modalities. So that's kind of where this is taking us. So each state has statutes that specifically define the legal limits for the practice of nursing within the state and that identify requirements for licensure. These are generally referred to as your Nurse Practice Acts. So as I mentioned last week, North Carolina was the first state to pass that first Nurse Practice Act, and that was in 1903. So prior to 1903, nursing practice was unregulated, and any person could define and practice nursing pretty much in any manner that they felt. So it's thought that the implementation of the Nurse Practice Acts, that the State Board of Nursing's protect the public, their health, and it ensures the safe practice of nursing for further defining those qualifications for licensure, scopes of practice, and title protection. So the most direct role that the State Board of Nursing plays is that of granting licensure or granting someone the right to use the title registered nurse. In recent years, the NCSBN, so that National Council of State Boards of Nursing, um, they are the agency that administers the NCLEX exam. They have developed a new regulatory model for the profession of nursing, and a mutual recognition of licensure model known as the Compact, Nurse Licensure Compact. We kind of talked about it last week. Allows a nurse to maintain one license in their state of residency, but they are able to practice and be recognized in another state physically or electronically, subject to each state's practice and law regulations. So no one person has the unequivocal right to practice nursing. A nursing license is a privilege granted by the State Board of Nursing, and that is based upon the license meeting all requirements for initial licensure or renewal of licensure. So last week, I know I talked about like your initial licensure and all of that, having to graduate from an accredited program and all that kind of stuff. So every 2 years in the state of Arkansas for renewal of license, you renew based off of your birth year. So if your birth year ends in an odd number, you renew every 2 years on the odd number. If your birth year ends in an even number, you renew every 2 years on the even number. So, like, I was born in 1996, and I have to renew on the even years. So I will have to renew, my license is up for renewal in January, because my birthday falls in January. So it's January, like your birth month, of the even year. Now, I will say, I graduated on an odd year in August, and then I turned around in January and had to pay for renewal. So some people do have unfortunate luck like that whenever they get their license, have to renew it like immediately. Um, but in those kind of situations, you are exempt from most of the renewal requirements since you're not even a year out. But typically for renewal, you have certain things that you have to meet, like your continuing education credits and things like that. And each state outlines those in online, and you can typically access it through your portal. They can audit you. They don't do it every year, but if they do audit you, then you have to be able to prove and provide that you have done your continuing education credits. Typically, if you work at a hospital and you're doing all of your hospital CEs and stuff like that that you have to work there, you're going to be fine. You'll meet everything. And you can just request a copy of that from your HR or the education department. They can send a copy for you to send over to state board. If you are not working at a hospital or somewhere that requires continuing education every year, um, if you go back to school, like I just finished my doctorate, so all of those count as continuing education credits as well. So all I would have to do is say, hey, I just graduated with my doctorate in December of 2024. Here are all of my transcripts and things like that. Typically, as long as you can provide proof that you have done them, they're not going to give you any kind of pushback or anything like that. So, standards of nursing care. So, nurse practice acts don't dictate how to perform procedures associated with the daily functions of a nurse. So, nurse practice acts are just a general guideline, okay? Standards of care are that degree of care, expertise, and judgment that is exercised by a reasonable person under the same or similar circumstances. So it requires a nurse to use the level of care that a reasonably prudent nurse would provide under the same or similar circumstances. That's the technical definition. And I think I mentioned that last week. So, sources of standards of care. This is also kind of a little bit of a review. You have your professional nursing organizations, nursing literature, your federal and state regulations, Joint Commission, your court decisions, professional experts, and then your clinical practice guidelines. So, civil liability is any injured party or the plaintiff can initiate a civil action against a wrongdoer, who is the defendant, for unreasonable conduct. If the plaintiff can provide by most of the evidence that the defendant's actions or inaction caused or contributed to the plaintiff's injuries, then the defendant will be required to monetarily compensate the plaintiff. So civil actions are based on tort law, and they are classified as intentional or unintentional. So I kind of want to pop back up to this second bullet point right here, and point out that it says actions or inaction. So even if you don't do something and you should have, and it can be proven that you should have been like able to know to do this, or you should have known to do this. Say that there's a patient who you can't find a pulse on and you put them on the monitor and they're asystole. Well, say you fail to initiate CPR. That is an inaction. Like, you should have initiated CPR, unless they're a DNR. That's a whole other can of worms. But if they are a full code, and you fail to provide those life-saving measures that are obvious to most nurses, that if you find a patient pulseless and without a rhythm, then we start CPR. If you fail to do that, that is basically what this is talking about. Okay, so negligence. So it's the unintentional conduct that falls below a standard of care established for the protection of others against unreasonable risk of harm. So there's 4 different elements. They are: the defendant owed a duty to the plaintiff to use reasonable care. The defendant failed to conform to this standard of care, which is also known as a breach of duty. There is a reasonable, close, casual relationship between the defendant's conduct and the plaintiff's injuries. And the plaintiff suffered actual loss or damages. So those are your 4 elements of negligence. Then we go on to professional malpractice, which is a specific type of negligence, and it results when a person fails to perform their professional duties in a reasonable manner. So for professional malpractice, I kind of hit on that a little bit at the beginning of the slide, so kind of refer back to those points for this as well, but it's just stating that it is a type of negligence. Judges and juries rely on appropriate standards of care to determine the reasonableness of the professional's conduct. So we have to have those standards of care to be able to determine what a prudent nurse would or would not do. So the plaintiff in these cases must prove several different factors. They have to prove duty, breach of duty, causation, and damages. So duty, breach of duty, causation, and damages. What are these, you may ask? We're fixing to talk about all of them. So duty is the first element of any malpractice claim. The plaintiff must provide that the nurse owed a legal duty to the plaintiff to deliver the appropriate standard of care. It's defined as an obligation to act or refrain from acting. And a nurse generally does not have a duty to render assistance at the scene of a car accident, but if the nurse does render assistance, the nurse must not have negligent care. So that means don't practice outside of your scope of practice, things like that. Now, in a hospital, it's a different story, especially if they are your patient and you're responsible for them. But things like helping at the scene of an accident, you're not required to render assistance, but you are required to not provide negligent care. Good Samaritan laws on that topic, they they do protect people who are rendering emergency aid, and they protect from liability. So that is only provided that they use reasonable and prudent judgment under the circumstances based on their education, training, and skill level. So like I said, just not practicing without outside of your scope of practice. If there is a nurse patient relationship, there is a duty on the part of the nurse to act or not act. So once nurses are assigned to care for a patient, this relationship commences and a duty arises. Kind of like I said a minute ago, it's not necessarily a duty if you're helping at a car accident, but it is if they are your patient and assigned to you. So a duty can be established when a nurse is covering, so when someone goes out on lunch. So that's why it's always important if they say, hey, can you keep an ear out for my patients? That you know what's going on. If something is, a patient's been kind of haywire or something could go wrong, then you need to know about that because you have a duty to help that patient. And then in a clinic, the duty may arise through a simple telephone conversation. People call all the time to PCP clinics, or specialty clinics asking questions, and they're an established patient, and maybe you're the nurse for that doctor. So they are technically, it is your duty to help them. Okay. So, breach of duty is failure to perform according to a specific standard of care once a duty is established. Um, and then the standard of care is established through expert testimony and presentation of additional evidence. Causation is the next thing that has to be proven. So it is a determination that if not for the conduct of the defendant, the plaintiff would not have been injured and that the consequences of such conduct were foreseeable. All healthcare providers have a responsibility to foresee harm to those for whom they care and take steps to eliminate, if possible, or at least mitigate that harm. And then lastly is damages. So the plaintiff must show that he or she suffered injuries or damages as a result of the nurse's negligent action. So courts can then award money damages in an attempt to return the patient as nearly as possible to their pre-injury condition or state. These are typically classified as general, special, or punitive damages, and it's basically meant to compensate the patient for any kinds of pain and suffering, disfigurement, disability, past and future medical expenses, and then lost wages and any future earning capacities. Okay, respondent superior. It is basically let the master answer. So, this is a key legal doctrine. It holds that an employer is responsible for the actions of its employees that occur within the scope of the employment relationship. So, thus, the nurse retains individual responsibility for negligence, but the liability is shared with the employer. So, the liability would be shared if this takes place in a hospital with the hospital's admin. It does not apply if nurses act outside the scope of the employment or scope of practice. So, say that your patient needs intubated and you intubate the patient. Technically, I'm not going to say that nurses can't, because there are very special situations where you can, but most nurses cannot intubate patients. Typically, the people who can do that are like your flight nurses, maybe a couple of really specially trained ER nurses or ICU nurses. But it's typically not like, you're on a regular floor intubating people. That's not how this goes. So, like, that would be practicing outside of the scope of your practice. And then indemnification. So the hospital may have the option to sue the nurse to recover the damages it paid. So you can not only be sued by the patient, but you can also be sued by the hospital if something like this happens. So defenses to negligence. Once a lawsuit is filed against a nurse, the nurse can raise defenses to the malpractice claim. So they have to have a valid defense. They need to assert that the plaintiff failed to prove just one of those four elements of the claim. Remember those four things that we just talked about: duty, breach of duty, those things. So they have to be able to prove that they failed to prove just one of the four elements of the claim. And then we have statutes of limitations. So this limits the time in which a plaintiff can bring a claim against a defendant. It depends on the state. Each state is different. Each situation is different. If that ever happens, you will have to just kind of look that up and go by what your state states for the statute of limitation. And then the plaintiff's own actions. So the law will not reward a plaintiff who contributed to his or her own injury by failing to act responsible and in a prudent manner. So an example of this would be failure to follow instructions or provide truthful information. So say that they didn't follow their post-op instructions and they got discharged from the hospital, then they developed some kind of funkity-dunkity infection, and then they're back in the hospital septic, having to undergo additional procedures and stuff. That's on them. Like, they didn't follow post-op instructions, something got infected, maybe they didn't come to their post-op appointments with their provider, things like that. Those are all going to be a defense for negligence, and that's the plaintiff's own action. So intentional torts. These are going to be planned acts that cause harm to another, although this harm may not have been expected by the person who acted. So in nursing, it is any willful act that violates the patient's rights. That's an intentional tort. So willful act that violates the patient's rights is an intentional tort. So examples of this can be battery, so touching of a person without his or her consent; assault, which is attempting to or threatening to touch a person without his or her consent; and then false imprisonment, which is confining a person without his or her consent. So false imprisonment is going to be restraints, and you guys probably learned about that with Miss Travis way back in Fundies. I know you did, because she does a whole module on restraints. So restraints are one of the big things for false imprisonment. That's why we have to renew those orders every 24 hours. That's why we have to assess cognition of the patient, why we have to provide routine assessments, why they have to be monitored a little bit more closely. And typically we don't put those on the floor, like a regular med-surg floor, super often. We'll try to put a sitter in the room with them or something like that, just because there's so many things that we have to do extra. Because if we don't, and we don't chart that we did those things, then it can be considered false imprisonment. Okay, so criminal liability is the nurse may be subject to criminal liability for inappropriate actions taken, in addition to the administrative disciplinary actions regarding licensure. So examples would be intentional torts, and inappropriate administration or recordings of controlled substances. So, decreasing elements of risk. So, obviously, some of these are going to be pretty obvious. So, maintain knowledge of state nurse practice acts. I know I hit on that last week in your lecture regarding nurse practice acts. So, every state is different. You need to know what your state's practice act says. If I said it once, I'll say it again. You really, really, really need to know those. Comply with and keep current with changes in standards of care, employers' policies, and procedures. Most employers and hospitals are pretty good about sending out modules whenever something major changes with patients and how we're going to be doing things. They'll have you do a module on the change and what the new policy is going to be and all of those things. Standards of care. So for me, I specifically am an ICU nurse and I am part of the Critical Care Nurses Association. So I get magazines in the mail and newsletters to my email, and those typically will have any kind of like major updates or any kind of research that's been done and evidence-based practice so that I can keep up with kind of what's going on. We also want to make sure we practice appropriate standards of nursing care, communicate clearly and consistently with not only patients but their families and other professional colleagues. Document your nursing care accurately, thoroughly, and consistently, and then practice adequate supervision of unlicensed personnel. So, your techs, your MAs, people who assist you, because ultimately you are responsible. If you ask them to help you with something, you're responsible for A, making sure that it is something that you can delegate, and B, that they know how to do it appropriately. Okay, so legal issues in nurse patient relationships. So, a nurse's duty to his or her patient supersedes all other nursing activities. Patients have legal means to gain control over their health care, and that includes access to care, treatment, decision making, and security of health related information. So, we have things like the Patient Self Determination Act, the Health Insurance Portability and Accountability Act, also known as HIPAA, and then the Patient's Bill of Rights. So, all of those things are going to basically give patients the right to protect their personal information, their personal health information, the right to make their own decisions as long as they are of sound mind and body. So, the decision making, the treatments, and then their care. So they basically have the right to deny, accept, ask questions, obtain informed consent, all of those things. And speaking of informed consent, so consent is patients, they basically get to be told everything about what the procedure is going to do, the risks versus the benefits. Um, it has to be voluntary, and the patient has to be competent in order for it to be valid. So, if the patient has dementia and they're confused as a Bessie bug and they think it's 1932 and I don't even know who was the president way back then, but obviously, someone's not the president who's already been dead for several years. They're not going to be competent, okay? So they cannot obtain that informed consent. Typically, at that point, if they have a spouse, that's who it goes to. And from then on, it goes down to like oldest adult children, siblings, parents, grandparents, things like that. So, what constitutes informed consent? It varies according to jurisdiction, but courts apply one of three standards. So, we have the physician based standard, and a physician, nurse practitioner, or physician's assistant has a duty to disclose any information that a reasonable physician in the same or similar circumstance would disclose to the patient for consent purposes. We then have a patient-based standard, and that is a physician, a nurse practitioner, or a physician's assistant must disclose any information that a reasonable patient would consider material in making a decision regarding his or her treatment or care. And then we have the hybrid standard, and that incorporates physician-based standards and patient-based standards. So regardless of the standard, obtaining an informed consent generally requires the care provider performing the treatment or the procedure to discuss information with the patient. So, like I said, that's going to be the diagnosis, the nature, and the purpose of the therapies or procedures, risks versus benefits, outcomes, reasonable alternatives, and then prognosis if the therapy or procedure isn't done. So, like I said, it must be voluntary without coercion. Silence cannot be construed as consent. So, you have to have a yes or a no, or yes, I understand and agree. No, I don't understand. I don't want this. You can't just go based off of a silence. Only a competent patient can give informed consent. And it is the responsibility of the person performing the medical treatment or surgical procedure to obtain the informed consent. Let me repeat that. It is the responsibility of the person performing the medical treatment or surgical procedure to obtain informed consent. So, you as a nurse will typically not be performing that medical procedure or surgical procedure. It is going to be the doctor, the nurse practitioner, the PA, whoever who has to get that informed consent. You, as a nurse, will be a witness to that informed consent. The surgeon or physician has to sign it, and then so do you, and so does the patient. You are there as a witness, and when you sign your name as a witness that you are witnessing an informed consent, you are stating that that patient is of sound mind and body, that they do agree to the surgery, and that the surgeon has adequately explained all of the things that they have to and answered all of the patient's questions. 9 times out of 10, the surgeon will try to walk out of the room because it happens all the time. And I'm here to tell you, you better make sure that that patient does not have any kind of questions before you sign that paper, because the surgeon will sign it and then they'll basically leave it up to you and the patient to finish signing it, and they'll meet you in the OR. So if they walk out and that patient asks a question that you can't answer because the surgeon hasn't already answered it, then you're going to have to call that surgeon back and they're going to have to come back to bedside. Now, if it's something that they explained in the middle of explaining everything and it's just a lot of information, you can reinforce and reiterate what they've said because they've already presented that information. But if it's something that they haven't already answered, you've got to call that person back. Okay. So a primary role for the nurse, or the primary role for a nurse, like I said, is witnessing, but also you are the patient's advocate. That is your big thing, okay? Patient's advocate is your number one priority, your number one role. And then your secondary role is to witness. So you need to determine the patient's level of understanding. You need to identify any patient fears or misconceptions, provide information regarding nursing care, contact the appropriate care provider if you doubt that your patient is understanding, document questions asked and information provided, and then notify your supervisor or follow your institution's policy if you believe the patient's consent is not voluntary or competent. So like I said, whenever you're witnessing that that patient is giving consent voluntarily, that they are lucid and competent, and then that signature on the consent form is that of the patients or the legal guardians or the healthcare proxy agent. So, minors and informed consent. So, minors obviously are anybody under the age of 18. They are incapable of providing a valid legal consent because 18 is the age of legal consent. A parent or a court appointed guardian must provide consent for the medical or surgical treatment of the minor. Statutory exceptions that exist, and there are some statutory exceptions that exist in some states. So we have what we call a mature minor, a minor that has demonstrated to a court that they possess the maturity to choose or reject a particular health care treatment despite chronological age and is allowed to consent to treatment. And then an emancipated minor is one who is financially independent and living apart from his or her parents, guardian, they're married, or they're in the U.S. military. They have the same legal capacity as an adult and they may consent to treatment. So, some exceptions, statutory exceptions that can exist in some states include HIV treatment, um, the prevention or treatment of pregnancy, treatment for physical abuse, and then treatment for or counseling for substance abuse. So, some other consent issues. So, those not capable of consent includes patients that are adjudicated by the court as mentally incompetent, patients that are intoxicated with drugs or alcohol, patients in shock, and patients that are unconscious. In the case of an emergency, healthcare providers act in the absence of express consent and provide care to the patient if the patient is unable to give consent due to intoxication, mental incompetence, or the patient is incoherent or unconscious. There is a risk of serious bodily harm if treatment is delayed. A reasonable person would consent to treatment under the circumstances, and the patient would consent to treatment under the circumstance, or the healthcare provider has no reason to know that the person would refuse treatment, i.e., they're a Jehovah's Witness, a Christian Scientist, things like that. So this is going to be like your patients who are trauma patients who roll up into the ER from an NVA, they're coding or about to code. There's no family with them. You don't know who their next of kin is. So you're going to act as though they want everything done because not providing treatment is going to make this patient die. And especially in like an otherwise young, healthy person, um, that we just automatically assume that they would want everything done until we get word from a family member or next of kin or whoever that, oh, hey, no, they don't want this or they're a DNR. Until we have those documents and until we see and hear from the next of kin that that is what the patient wants, we have to act as though the patient would want everything done. Okay. Therapeutic privilege versus a patient waiver. So, therapeutic privilege is the physician determines that certain information may be detrimental to the patient's physical or emotional well being, and that full disclosure should not be made. Risky practice and requires detailed documentation of circumstances surrounding the decision. So we typically really try not to do this if we can get around it. And when we do, we have to document in detail why that decision is being made. The information is disclosed, withheld, and we have to document the reasons and rationales for withholding that information. So, a patient waiver is the patient may decide that they don't wish to know or discuss the various aspects of their care and that they simply place their care in the hands of their trusted physician. So, detailed documentation is essential still for this, and a patient can revoke that waiver. Okay. So, failure to obtain consent. So, this can have significant consequences for the healthcare team. Providers can be sued for battery, negligence, and if a nurse knows or should have known that informed consent was not obtained and they failed to make the physician or nursing supervisor aware, then that nurse can also be liable. Like I said, this isn't going to be for like your emergency cases that roll into the ER and you don't have any next of kin and you're just going off of they would want everything done. Now, if something happens and they come back, then whatever you're doing, you have to stop immediately if they tell you no. But until proven otherwise, that is an exception to this. But if a patient's going for an outpatient procedure and you get halfway through the surgery and realize that informed consent wasn't obtained, then that's kind of problematic. So not only can you but the doctor be held liable, the hospital, it's a whole slew of people. So the right to refuse medical treatment. This is part of a patient's right to self-determination. They also have to be competent and of sound mind and body, and they can refuse any proposed treatment or procedures. This includes life sustaining or saving, or those motivated by religious beliefs. A big one here is going to be your Jehovah's Witnesses, who typically they do not take blood or blood products, and maybe all the patient needs is a blood transfusion, and without it, um, you know, it's going to be really, really hard for the patient to recover. That is completely within their right. If they or the person who's making the decision are of sound mind and body, that is completely within their right to refuse treatment. Refusal of treatment must be um, predicated upon information. So the nurse has a legal duty to the patient to ensure that the patient has the necessary information to make an informed refusal. And then cases involving incompetent, terminally ill patients and termination of care in minors honestly are kind of complex. It's going to fall to the next of kin and your physician being your point of contact. Sometimes you will get the ethics boards of hospitals involved if the situation is really, really complex. You'll see this a lot with minors. But typically, as long as they can prove that they are of sound mind and body, and especially if there's a living will or anything like that that the patient had prior, they will use that to go off of decisions that are being made as well. Okay. So, privacy, nurses have access to a ton of personal, private information about patients and their families. So, the right to privacy protects more than the patient's medical record. It protects them from unauthorized photographs in news stores, as well as unauthorized observations by others, even if those others are hospital personnel or healthcare students. The Constitution does not explicitly provide for a right to privacy. The Supreme Court of the U.S. has nevertheless held that the Constitution does indeed offer such protection. And this has profound implications for the practice of nursing because a right to privacy guides courts in deciding significant healthcare issues. So, issues such as patients' rights to reproductive autonomy, the right to refuse medical treatment, and the right to die. And then advances in technology have increased the potential for intentional and unintentional breaches of confidentiality. So, some exceptions that may allow disclosure of confidential information is if the patient gives verbal or written permission to release information. If you have ever gone to the hospital or to the doctor and had to fill out a bunch of forms, it's usually got like a place where you can put a couple people's names that they can call and obtain information or get your health records. Most people put like their parents, like I know my mom and my dad, and then like my husband are on mine. Other healthcare workers who have legitimate reasons to know information, so reports to the charge nurse, things like that. Or if someone is like watching your patients for lunch and something happens, then they would also be included. Statutory or legal duty to report. So this is going to be if there is any kind of communicable disease, child abuse, gunshot wounds, all of those things have to be reported, and that is a legal thing. And then there is a duty to warn, so serious threat to an identifiable victim. So all that kind of falls in with the legal side of things as well. So breach of confidentiality. So this exposes the nurse and their law or employer to lawsuits and federal or state legal action. The nurse can be subjected to disciplinary action by their state board of nursing, and the nurse can and most likely will lose employment. Let me tell you, you can also lose your license. Okay. Um, State Board of Nursing, especially in Arkansas, does not play with HIPAA violations and things like that. So never access a patient's chart unless you have a reason to. Um, and just keep that in mind that it is a federal legal state board of nursing, all of the above can come after you for breaches of patient confidentiality. And then social media. So, nurses must always remain aware of their professional obligations, as well as employer policies and state and federal law when using social media. They must avoid disclosing patient related information, and then some state boards of nursing have specific regulations regarding a nurse's inappropriate use of social media. I'm just going to tell you right now, if it ain't something that you would let your mama, your daddy, your granddaddy, your pastor, whoever see, you probably shouldn't put it on social media. Um, I will say, and you can believe me, you don't have to, but your employers, when they go to hire you, they will do a deep dive on your social media. I have seen it happen, and I have seen them question um, people's posts and things like that because ultimately you are representing the hospital or wherever you're going to work. You are representing the profession of nursing. You are representing your state board. You are representing more than just yourself. And yes, while everybody has the right to freedom of speech, you have the right to do whatever you want to do on your own time. Um, they do look at that kind of stuff. Um, so just be aware of that. Kind of like we've told you guys in the program that, like, be aware of what you post, what you say, things like that, because you're representing not only yourself, but us and the nursing profession. I say us as in the A State School of Nursing, and the nursing profession as a whole. So just kind of keep that in the back of your mind. But that is our last slide. I hope you guys have learned a lot. If you got any questions, just holler at me. Thanks.